Last week we talked about license discipline and its negative impact on those who have had license disciplines and how it impacts in regards to PPO and network applications, as well as malpractice insurance applications and pricing, and maybe even trying to get a license in another state, and how those things can follow and chase you for a very long time. This week I want to talk about certain situations where some physicians who have a discipline on their license may be able to address that, or at least request that those records be classified as confidential, which has the implication or the result of ineffective expungement for reporting purposes. So they wouldn't have to be reported to other jurisdictions when you get your license, as well as on network applications and malpractice applications. But it fits for only certain circumstances and only certain disciplinary offenses that took place, violations. So when does that come into play, and for whom does that come into play? First of all, you have to be at least 3 years past either the disciplinary action or when your license came out of probation. So basically, and it can't be on probation, so you have to have a free and clear unencumbered license at this stage, and it has to have been that way for at least 3 years. Additionally, you can have no other incidences of discipline, and you can't be under investigation. So if you have a prior offense and you meet those three things, then you may be eligible to apply to have those records classified as confidential. All right, so what does that look like, and what are those offenses? Well, they have limited to a very specific number of things. First of all, maybe it was a failure to pay taxes. You ran into some financial hard times and you struggled paying your state income tax, possibly your state sales tax obligations. That would be an offense that you could apply with IDFPR to have those records classified as confidential. Possibly it was a continuing education violation. You did not fulfill all of your requirements for continuing education. If you met those first three things, it's past that 3-year mark, and you're not under investigation for anything else, then that would also be a possibility. Maybe you didn't renew your license on time. You missed one of the deadlines for whatever reason that might be. As long as you're past that time frame, it would be an application possibility. Maybe it was an advertising offense. We actually had a member call recently that had purchased a national advertising campaign, and the campaign violated a number of different state statutes, and they ran the ad. And so that was what the discipline was on their license, and they would have the possibility, that doctor would have the possibility of actually requesting that those records be set as confidential. Now, if the discipline was based on a criminal charge, then it only fits in a couple of different categories. First of all, you have to make sure that the charge did not arise from the practice of chiropractic. So if it's a fraud charge in your office, that would be ineligible. Or if there was another charge that was criminal, that went against you as a practitioner or happened while you were practicing chiropractic, then that would be it. Or if those records were dismissed or expunged from your record, then at that stage you would also be able to apply to have those treated as confidential. So those are the only two very narrow areas where if it's a criminal conviction, that would be an issue. Now, if you had a prior criminal conviction when you first got your license and your license was placed on probationary status, that would be another time when it would be possible to at least apply to see if you could have those records treated as confidential after you've met those other requirements. So your license would have to come out of probation, and then you would have to wait an additional 3 years after that point. So now the last one is this, and if you have a prior discipline for something that is no longer even in the act as a violation, a really key item here would be a testimonial. So the Supreme Court struck it down, and then they have actually removed it now from the Medical Practice Act, the prohibition on testimonials. So as long as you weren't in violation of another provision of the act when you had that offense come up for testimonials, then at that stage you would also be then eligible to apply for to have those records treated as confidential, which has the effect of being expunged. Now, those records could still be shared with other entities doing background checks or whatever the case might be with the police, etc. However, they would be treated as confidential for all of your reporting purposes and other licensing bodies in other states, and malpractice and network applications, things along those lines. So hopefully this helps you out. Now, I want to also make sure this is clear. I'm going to leave a link in the bottom of this video to make sure that you get a link to the form, number one, and also know that it's still up to the discretion of IDFPR. So you'd fill out the application. Please read the instructions for that application very, very closely. It's $175. Make sure you submit the $175 with that particular application for confidentiality and to get it off to the department. And hopefully this helps some of our doctors who may have run into some challenges early on in their career. We'll catch you next week.